when we are interpreting the Constitution, we read provisions of the Constitution alongside each other to maintain a rational explication of what the Constitution is intended to mean. What that rule then requires in terms of constitutional design is that there ought not to be an intentional inclusion of conflicting constitutional provisions. Otherwise, then the rule of harmony or harmonization then falls apart.
So at those stage, you said that this inclusion of this will be conflicting.
Yes, my Lord. What we argue also with respect to the second rule on the purposes or consideration of the purpose of the Constitution, specifically, my Lord, our concern is with the inclusion of the Senate Oversight Fund. When you look at Article 221(3), as read with Article 127(6)(c) of the Constitution, there is a very clear constitutional intention to establish the funding mechanism for the Senate as an independent funding mechanism that is then undertaken through the Parliamentary Service Commission. The purpose for that independent funding mechanism is to ensure that the funding of the Senate is so independent to facilitate the separation of powers and the oversight role of the Senate. When we then come up with a constitutional amendment that seeks to now fund the Senate through the national executive, the question that this court then ought to ask is the goal, the constitutional purpose of independently funding the Senate to facilitate its oversight role, will it still be in harmony with this goal of funding the Senate through the national executive, or will it undermine that particular purpose? And the question, my Lord, we ask is, do the people of Kenya envision a constitutional amendment that seeks to include an amendment that undermines or undercuts or conflicts with a very clear constitutional purpose, but importantly, without specifically indicating that the purpose is to overturn or oust that constitutional purpose of independently funding the...
But that apparent conflict, or what you refer as conflict, don't you think it can be cured by the procedure used? Because if you allege that Parliament is selfish, they want it on this fund, so then you do a referendum and you let the people decide.
My Lord, that is indeed correct, that a referendum, as I mentioned, my Lord, the people of Kenya have a right to amend the Constitution. It's their social contract. If they amend the Constitution to include conflicting provisions, my Lord, that is up to them. But now our issue, my Lord, is that Parliament that is tasked with ensuring the protection of the Constitution is engaging in conduct that is intentionally going to inject a conflict within the Constitution, in the sense that that constitutional purpose of independence of the Senate to facilitate its oversight role is going to be undermined if we permit the current constitutional amendment to go ahead. And our argument, my Lord, is that an amendment that conflicts with a clear constitutional intent without specifically seeking to withdraw or change that particular constitutional purpose ought to be declared unconstitutional. Now, the second question, my Lord, is whether it is permissible for the National Assembly and Parliament to go ahead with an amendment where the Constitution has provided a clear mechanism of attaining that particular objective. My Lord, in the TISA case, the Institute for Social Accountability case before the Supreme Court, which has been cited in our submissions, when the Supreme Court was declaring the National Government Constituencies Development Fund as unconstitutional, one of the things that the court said is that the purposes for which this fund is seeks to be implemented can be implemented within the current constitutional framework. Now, what this Constitution Amendment Bill seeks to do is to include the National Government Constituencies Fund, the National Government Affirmative Action Fund, and the Senate Oversight Fund into the Constitution. Now, the position of the Supreme Court is that the first fund can be implemented perfectly well within the current constitutional framework. The National Government Affirmative Action Fund is currently being implemented through the Public Finance Management Act regulations, correctly and lawfully within the current constitutional framework. And the third fund, which is the Senate Oversight Fund, there is a very clear procedure under Article 127(6)(c) and 221(3) that allows for the funding of the Senate. When you look at Article 96, my Lord, the role of the Senate, there are 4 roles of the Senate. 2 of them relate to oversight. And Article 127(6)(c) and Article 221(3) specifically provide for how the Senate is to be funded. And the question, my lord, that my client asks is, what should be the fate of a constitutional amendment by Parliament that seeks to effect a change that the Constitution as it is currently is capable of addressing? And my lord, the Supreme Court in the Tisa case, my lord, indicated that the constitutional imperative under Article 202 with respect to 201 C and D with respect to the prudent and responsible use of resources ought to direct that the government institution picks a more prudent route insofar as attaining that policy objective is concerned. And therefore, my lady and my lords, the questions that we are asking is, what is the role of this court in those situations where Parliament seeks to amend the Constitution in a manner, 1, that defeats its purposes, and then 2, in a manner that then only duplicates what the Constitution already provides for, especially in light with the imperative under Article 201 C and D with respect or that requires Parliament to prudently ensure or to ensure the prudent and responsible use of resources. And our submissions, my lord, is that that attempt by the National Assembly ought to be declared unconstitutional, given that it undermines the constitutional text, and importantly, my lord, it undermines constitutional principles that have been outlined in the Constitution, and my lord, that is our submission. Most obliged.